Well, good afternoon, everyone. I'm David Glazer, and I'm here with this month's webinar, which is on voluntary refunds, the 60-day rule, and more. As usual, we have a few boring announcements. They'll be really quick. First, if the sound goes south, remember, you always have a dial-in option. Robert is typing that right now. It pops up in the chat box. If you have a hard time seeing the chat box, the magic way to make that happen is move your mouse to the middle center of the top of the screen, and that should make the box appear. You can see messages there, and you can also type if you've got questions, and we love to get questions. Toss it right out there. Marguerite has agreed to help sort questions out, and we may even be able to ask them during the presentation. If the sound goes bad, you can use the dial-in at any point. Remember, the internet is the one thing that's outside of our control. We do look at the evaluations, and in particular, if there's any hiccups, please let us know. I know some people had a hard time getting the email this morning. It's weird because I know most of you got it, but a few didn't, so we apologize for that. But we're also really interested in topics. July 13th, our next topic, actually the next two, I believe, are set. So July 13th, Steve Beck and I are going to talk about value-based topics. So MIPS, a very little bit of CJR because we've already covered that, but sort of some of the transformation that's happening in a value-based world. And then in August, a topic that is always super popular, our grab bag frequently asked questions. I know Katie Ilton is going to be coming back for that. I'll be doing it, and probably some of my other colleagues. Now, let's dive in. Gary Larson is one of my favorites, and this cartoon encapsulates how many people feel about doing a voluntary disclosure. It's the belief that if you go in and stick your head out of the foxhole, so to speak, now stay calm and let's hear what they said to Bill. I will use a Gary Larson cartoon anytime I get the chance. People think that if you voluntarily disclose, bad things are going to happen. In my experience, that is not the case. I've really only had maybe two voluntary disclosures that did not play out as hoped. It's pretty rare. I mean, because I couldn't count the number that I've been involved in. I mean, it's in the hundreds. So it's pretty rare to have a problem. But things are changing a little in how stuff has to happen. So the Affordable Care Act had, I'm sure most of you know, a 60-day rule that required the reporting and returning of any Medicare or Medicaid overpayment within 60 days of when you identify the overpayment. Now, the statute left questions. One biggie, what's an overpayment? The other biggie, what's identification? A regulation is going to came out. It's effective now. It took effect. Wow, I'm blanking on the date. I want to say it came out like on February 12th. I think it took effect March 13th. But there's a final regulation that answers some of these questions. But a couple of things to keep in mind. I will often forget this. The regulation only relates to Medicare. The statute relates to Medicare and Medicaid. The regulation is Medicare specific. But most of what I'm going to talk about until the end is focused on Medicare. The answers for Medicaid can be slightly different, and the answers for all other payers can be slightly different. So keep that in mind. In particular, we're going to talk about some time limits for Medicare. Medicaid time limits are totally state-specific. And for example, the state of New York has at least one case that says you can go back for forever. A little crazy, but true. And other states have affirmative limits on how far back the state can go. So here's just a quick look at the statute. And I tried to put lots of citations in here for the lawyers. We've got a mix of lawyers and none. If you want to look things up, for most of our slides, there's a citation, so you can look things up. So generally, you have to report and return an overpayment, and it gives you the option of doing that to the secretary, the state, an intermediary, a carrier, a contractor. You get to choose what method you'll use, and we'll talk more about that later. But you have to explain what happened. That is a requirement in the statute. You can't just send the check in, you have to give a reason. Now, in the statute, the deadline just said that you had to report and return the money by 60 days after the date on which the overpayment was identified, or if you were working with their cost report, within 60 days that the cost report was due. Okay? Now, one other interesting thing about the statute, it has a weird quirk. It defines the word knowing and knowingly and says that it's the same as under the False Claims Act. Having defined those words, the statute then doesn't use them, all right? And this is gigantic because CMS uses the definition to say, we think Congress meant to impute a knowing requirement in there, and a knowing requirement that has reasonably should know as its basis. So you actually know or you reasonably should know, and they then, through the regulation, are expanding the definition of overpayment to include not just things that you actually know about, but things that they think you should know about. That's a really big change in my mind from what's in the statute, and is probably one of the most significant things in the regulation. And so it really leads to this question of what do you know? So the law said you have to report and return an overpayment. And if you had asked me before February, I would say you only have a duty to report money you know you've received improperly, because I would say if you don't know about it, you haven't identified it at its most basic level, right? You have to report and return an identified overpayment. If you don't know you have an overpayment, you haven't identified it, no duty to report and return. That's what I would have said under the statute. That is not what CMS is saying in the regulation. So the regulation says that you've identified an overpayment when you either have or should have, through the exercise of reasonable diligence, determined that you received an overpayment, okay? And it then goes on to say that you should have determined that you received an overpayment if you fail to exercise reasonable diligence and you did in fact receive an overpayment. So, I mean, if you don't look and you don't have an overpayment, you're fine. But if you don't look and you do have an overpayment, CMS is in this rule trying to create an argument that you still have a duty to return it even though you don't know about it. I should have probably started the talk with this. This rule is an interesting one. It creates challenges on the risk tolerance spectrum. I'm going to be giving you the Glaser perspective on a lot of this stuff, where I think CMS's position is unsupported by the law. A difficult decision everyone who's listening to this and I have to make in each one of these is when you decide to fight and when you decide to go along with the CMS position. And I don't think that's the answer to that is always going to be obvious. And frankly, I might make that on a case-by-case basis. But I will be somewhat aggressive in my description here on the take on the rule, with the acknowledgement that many people who are rational may choose to be less aggressive and go with the flow. And I think that's always the choice you have as an organization and as a client. But I think if you decide to do what CMS says you should do it knowing what your options are. So keep that in mind as we go on. So when you see at the bottom of a slide, like here I've got 81 FR 7660, that's the citation to the Federal Register that shows you the page in what's called the preamble. So when a new rule comes out, there's text before the rule called preamble that explains the government's take on things. And a lot of my slides are going to be direct excerpts from that preamble. So while we acknowledge the terms knowing and knowingly are defined, but not otherwise used in the law, we think Congress meant the law to apply broadly. If the requirement to report and return overpayments only applied in situations where you had actual knowledge of the existence of an overpayment, then these entities could have avoided returning the overpayment and the purpose of the section would be defeated. Now, this is not the first time that CMS has said Congress meant to say something it didn't say, and so we're sticking it in. Those of you who have heard me rant before about applying the anti-markup rule to the professional component of diagnostic tests know that CMS did the same thing. They said, we're sure Congress meant to include it, they just didn't. There's a real question as to whether a government agency has the authority to go where Congress has not. Conservatives would say they do not. The government would say we're just interpreting a statute. I do want to note the words providers and suppliers in here. Just as an aside, it is always good to recognize I try to avoid referring to physicians as providers. I try to call them physicians and then refer to physicians or medical professionals or something like that, because Medicare uses the term providers for facilities that are licensed. That have a facility fee. So hospitals, skilled nursing facilities, ambulatory surgical centers and the like. Suppliers are physicians, physical therapists, and generally professionals who bill. So this expansive reading continues. So CMS says that some commenters said that applying knowing to retained instead is what let's try that again. Suggested that we should use knowing and apply that to retained. They think that having a constructive knowledge standard is more appropriate than their proposal, and CMS rejects that, basically saying they think there's a strong statutory basis. So commenters are saying you need to actually know about the overpayment, and CMS is saying no, we don't believe that. Which leads to a giant question. For the first time ever, are you now required to do audits? And I think CMS's answer to that would be yes. I still have doubts about whether the answer is yes, but CMS clearly thinks that the answer is yes. We believe that undertaking no or minimal compliance activities to monitor the accuracy and appropriateness of a provider or supplier's claims would expose a provider or supplier to liability under the standard that we've articulated in this rule. We also recognize that compliance programs are not uniform in size and scope, and compliance activities in a smaller setting, like a solo practitioner's office, may look very different than those in a larger setting, such as a multi-specialty group. So the people who wrote this rule think you now have a legal duty to be doing audits. I'm not going to read through all of these, but I just note the last part, which is you have a duty to do self-audits, compliance checks, and other research. That's their position. I'm not buying that entirely, because I think that the law requires you to report an overpayment you've identified. But I have to concede identified is a little ambiguous, and that working in the reasonable test is something a court may permit CMS to do. So we don't know how courts are going to handle this. We're going to have to watch. Now, the regulation defines an overpayment as funds that a person has received or retained under Title 18, so that's Medicare, of the Act, to which the person, after applicable reconciliation, is not entitled to under the title. I've got colors up here for a couple of reasons. We're going to talk about reconciliation in a minute, and then not entitled to under this title is super important, and we'll come back to this. Remember, this regulation only applies to Medicare, which is why Title 18 is here. Medicaid is Title 19. Actually, this is so important, I'm even going to mention it now. I believe that if you're entitled to keep the money under the Medicare Act, it's not an overpayment. Actually, that's not what I believe. It's what it says here. That's the definition of an overpayment, is money you're not entitled to. And so if you're entitled to it, you get to keep it, and that's what we will be coming back to in a bit. Now, let's talk for a moment about after applicable reconciliation, because the government takes a very narrow reading of that. I would say that after applicable reconciliation means that if there's an underpayment, you can offset it. Once again, CMS would disagree. So they say that applicable reconciliation occurs when a cost report is filed. Okay, so their version of reconciliation is cost report specific. And in the preamble, they go through a very difficult to understand explanation as to why they believe that to be true. One of the flaws in their thought process is that discussion talks about both Parts A and Part B of the Medicare program. I don't think there's anything in Part B that features cost reports. And so I think that that's a shortcoming. I believe you can offset underpayments. It seems entirely consistent with the statute. I know I'm going to advise my clients to offset. If you find an overpayment and an underpayment, I think you can offset them. But once again, you should know I don't know that CMS agrees. Now, the biggest question, I think, under this regulation is how far back you must go. And we're going to dig into this pretty hard, and this has the potential to get pretty confusing. You may hate me at the end of this. The law had no temporal limit at all. And when I say the law, I mean the 60-day report and return requirement had no temporal limit. Back to if you're entitled to keep if you're an overpayment is money you're not entitled to, I would say that if there's something that prohibits the government from recouping the money from you, you do not have an overpayment, and the 60-day rule isn't triggered. So we need to look at the various statutory and regulatory provisions that prevent the government from recouping money. The Social Security Act has two provisions. They're found in 1870 and 1879. Then there are regulations that also limit reopening. Okay? Now, what makes this really interesting is that all of the different provisions use different terms. So 1870 and 1879 don't use the word reopening at all. The regulations, by contrast, talk about limits on reopening claims. The manuals talk about limits on reopening and recovery. It's a legal, this is like someone put legal analysis into a food processor and just turned it on and stuff comes out. I am not going to go through the statutory provision in microscopic detail because it's hard. And in fact, I usually refer to this as the most difficult statutory provision I've read. Every time I think I understand it, I read it again and realize I'm wrong. But 1870 of the Social Security Act has been interpreted by most courts that have looked at it as creating a provision that basically presumes the government can't recoup an overpayment after a certain period of time. And that period of time changed. It used to be 3 years after the year in which payment was made. And if you look at the slide, you'll see there are some capitals, all caps, fifth and five. In 2013, as part of the fiscal cliff legislation, this provision was changed so that now it's subsequent to the 5th year after the year in which payment was made. So this is a statutory limit, and it seems to be pretty absolute. Well, courts have interpreted it as being pretty absolute. Now, it acts in a really weird way. It focuses on the year payment was made, not the day payment was made. So let's say you have a payment that was made on January 4th, 2013. And I picked that date very consciously because the fiscal cliff bill took effect on January 3rd. So before then, we were talking about a 3-year limit. And this is still can be important. If you're dealing with an overpayment that has claims back before January of 2013, there may be a 3-year limit on the government's ability to recoup money. So if you get into an overpayment or a voluntary disclosure thing dealing with things from 2012 and older, remember this slide, okay, and come back to it. So if you have, but if we're in the present, they're going to focus on 5 years after all of the year in which payment was made. So you'd say 2014, 2015, 16, 17, and 18, and you can recover money up through December 31st, 2018. In the crazy, 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 crazy thing, if the payment had been made 12/31/12, then we lose a whole year on the recovery because you go into a payment being made a year earlier. Now remember, actually, you have a whole nother argument to be made, which is that there was really a 3-year limit there, okay? But I'll try to keep this simplistic. The key provision, or the key thing to understand here is this is a really hard to implement. Basically, now people often refer to this limit as 5 years, and that's misleading. This is a situation where simplicity trumps accuracy. And I promised myself I wouldn't use Trump in a speech, and now I've broken my promise. And I'm going to try to avoid making any sarcastic comments here. All right, so then, Social Security Act Section 1879 is a provision that requires the government to waive an overpayment if the provider or supplier did not know and could not reasonably been expected to know that the service was uncovered. And this can be really useful in a medical necessity situation, okay? And I've got the full language there. I'm going to sort of move on through that. So that's the statutory language. Now, let's look at the regulations. So these regulations limit the government's ability to reopen claims. And generally speaking, the government can reopen a claim for 1 year for any reason, for 4 years if there's good cause, and then they can go back anytime if there's reliable evidence that the initial determination was procured by fraud or similar fault. So if you boil this down into basic English, it creates a presumption that after 4 years, the government can only reopen the claim if there's fraud or similar fault. And this has been the limit that I and most healthcare lawyers who do this stuff a lot have used historically to say you need to go back 4 years when you recover an overpayment, all right? Or I'm sorry, not when you are doing a voluntary disclosure. Now, I should throw one caveat here, which is the definition of similar fault is broader than any normal mortal would think. Fraud or similar fault, in my mind, has to involve intent. That's what fraud is. If you actually look at what the regulation is, it defines similar fault as any time you obtain, retain, seek, or receive Medicare funds to which you know or reasonably should be expected to know that you were not legally entitled to. And this includes, it says, but is not limited to, failure to demonstrate you filed a proper claim. So this is broader, and this does give me a little pause because I always worry about whether a mistake constitutes similar fault under this definition. But this seems to create a regulatory limit of going back 4 years. The manuals very explicitly talk about limits. So this manual talks about how the government can only go back until the third calendar year after the year in which payment was made. This is operationalizing 1870. Now, this language hasn't been corrected to adjust for the fact that the law was changed to 5 years, right? But here's a manual saying that if a provider is without fault, and you're deemed to be without fault when you go back more than 3 years after the year in which payment was made, all right? So this is in the manuals. There's another manual provision that says if the contractor hasn't reopened a claim within 48 months, they can't reopen the claim unless fraud or similar fault is present, all right? So this is all in the manuals. Why am I going through all of this? Those things all seem to create a limit on how far back the government can go. The government in this rule rejects all of that. So here's how the government in the preamble talks about Section 1879. We believe it's inappropriate for providers or suppliers to make determinations regarding their own knowledge of non-coverage or whether they were the cause of an overpayment. So they're basically saying you, when you have to do a voluntary disclosure, can't decide that you didn't know about a provision or shouldn't have known about a provision, and so you can't use 1879 when calculating your voluntary disclosure. So a few things about this, okay? First off, they don't mention 1870 at all in the preamble. They completely ignore it. And I find this really shocking because I had submitted comments about this proposed regulation when it came out and said, hey, in the original proposal, the government said you could go back 10 years, or you needed to go back 10 years when doing a disclosure. And I said, you don't have the statutory authority to do that because there's 1870, and 1870 limits the ability to go back more than 5 years after the year in which payment was made. CMS does not talk about 1870 at any point in the preamble. They have completely ignored it, all right? Instead, what they say is that an overpayment must be reported and returned if the person identifies it within 6 years of the date the overpayment was received. So they're saying it's a 6-year look back. I think that's wrong. I think all of the things we went through there create statutory, especially statutory, because regulations, conflicting regulations are, it's not clear which regulation has priority over the other. But statutory, a statute trumps a regulation. And I don't know how they can ignore 1870, and I don't know how they can say that a provider or supplier doesn't get the ability to say, hey, we shouldn't have known about this overpayment, we're going to apply 1879. Because remember, an overpayment are funds that you're not entitled to under the law. And if the law says the government can't take that money from you or they can't reopen the claim, I think you're entitled to the money and there's no overpayment, and then the 60-day report and return requirement isn't triggered. So hopefully that made sense. I think that they are going well above and beyond their authority. They disagree, all right? So question, or a commenter says, we've questioned whether that they have the responsibility to go back more than 3 years if that Iraq can go back. Yes, as we've discussed previously, this final rule clarifies that when a provider or supplier receives credible information of a potential overpayment, they need to conduct reasonable diligence to determine whether they've received an overpayment. RAC audit findings, as well as other Medicare contractor and OIG audit findings, are credible information of at least a potential overpayment. Providers and suppliers need to review the audit findings and determine whether they've received an overpayment. As part of this review, providers and suppliers need to determine whether they've received overpayments going back 6 years, as stated in this rule. So the government's position is that a RAC, which can only look at you for 3 years, comes in and looks at you back 3 years. You've got to do the additional 3 on your own. Or a contractor, which can reopen a claim for 4 years, you've got to go back an additional 2. I was explaining this to a reporter, and my son was in the car. And I hung up, and he's 13, and he said, "Dad, this is crazy." And my son is right. This is crazy. I also continue to think it's wrong. Okay, now, first thing, whether it's wrong or not, it is important to understand that even under the regulation, they define the operational date for that 6 years is when you identify the overpayment. And an overpayment isn't identified until it's quantified. And that means that you go back 6 years, not from when you get a phone call saying, "I think we have a potential overpayment." So if you get a call January 1st, "I think we have an overpayment." You start looking at it. In February, you decide you probably have an overpayment. You start doing some math. At the end of April, you figure out the amount that's due. That's when the 6 months, or I'm sorry, the 6 years runs back from when you've quantified it at the end of April, not the date of the first phone call in January. Now, what's kind of weird about this is it almost creates an operational impossibility, which is you don't know the date you're calculating until you've calculated your amount, right? So how far back do you need to go? Well, you don't know till you're done. It's an interesting little mind game. So let's bring all of this home. I'm afraid I have made this really, really messy, and let's see if I can try to make it pretty simple. The government thinks you have to go back 6 years from the date you've quantified the overpayment. They're completely ignoring conflicting statutory guidance. So you've got to make a decision. Are you going to choose to follow what they're doing and go back the 6 years, or fight? And you might choose that, I think, reasonably based on the amount of money involved and a whole bunch of other factors. Now, an important thing to consider is whether you need to make the decision now, or can you decide on a case-by-case basis. So those of you who are have been around for a while, I was going to say old like me, but who've been around for a while, may remember that as part of the investigational device case back in the 90s, a bunch of hospitals sued, arguing that the manual provision involved violated the Administrative Procedure Act. And that lawsuit got thrown out because there's a statute of limitations for how long you can challenge the validity of a rule. And this is actually really weird because the APA is all about whether you've got proper notice of a rule. Oddly, there is a time limit as to how long you can wait to challenge the fact that you didn't get proper notice of a rule. That's another one of these logical mind games, because you're saying I didn't know that this rule was there, and there's a limit as to how far back you can go. But that was in that case, the hospitals were seeking a declaratory judgment. If you want to go in and get a declaratory judgment, you probably need to do that under the APA. As I understand it, you can always use a statutory argument as a defense when the government comes after you, or a relator does, and argues you've broken the law. So I don't believe, although I have not exhaustively researched this, but I do not believe that you have a legal duty to make the decision now. But if you were ever in a situation where you want to go to court and get a court to tell you definitively that you don't have to go back more than 4 years, that there is probably a statute of limitations ticking on right now. Okay, now we're going to move on to a variety of different topics, some of which are from the rule, and then we're going to talk about more about voluntary disclosures generally. So first, here's a statement that's in the preamble that I find to be completely incorrect, and that's really important. Some commenters stated that the concept of overpayment isn't fair in some situations. The commenters said that certain reasons for an overpayment, such as insufficient documentation or lack of medical necessity are extremely difficult to define objectively. Response. The definition of overpayment is fixed in statute. Sufficient documentation and medical necessity are long-standing fundamental prerequisites to Medicare coverage and payment. Those of you who have known me for years know that that is not true, and we're going to talk about that in a little bit more in a moment, but the absence of documentation in most cases doesn't automatically create an overpayment. So I'll have a few slides about that, and I'll send you to a whole webinar. This is just legally incorrect. There's some language in here that suggests that the government now thinks in some certain situations you have a duty to report illegal conduct. So to the extent that a provider or supplier who has received an overpayment resulting from a kickback arrangement and is not a party to the kickback arrangement, but they have knowledge of the arrangement to have identified the overpayment, the provider or supplier must report the overpayment to CMS. Well, that's kind of an interesting one. They're arguing here that if you are aware that a doctor got a kickback, you're a hospital and you find out a doctor's got a kickback, you have a duty to report. I think this is on somewhat legally tenuous ground as well, but just note that's CMS's position. Generally, remember, you don't have a duty to report crimes. There are limited exceptions for that. Child abuse is a biggie. You do, if you've gotten money that you're not entitled to, have a duty to report. But here, if you didn't receive the kickback, I think that it's pretty hard to argue that you have an overpayment and then you didn't have a duty to report. And CMS half acknowledges that, saying our expectation is that only parties to the kickback scheme would be required to repay the overpayment. So that's an interesting one. If you're not required to repay the overpayment, then you don't have a duty to report, but in any event. There's an interesting discussion in there about appeals following a refund. And they talk about the fact that any time you have an individual claim adjustment, you get an appeal right. But if you do a refund that's done on statistical sampling, there aren't any specific claims that are reopened. And so if you were to refund money off of a statistical sampling, you cannot avail yourself of the appeal process. Now, you may think, why would you ever want to appeal after you do a voluntary disclosure? Well, I've done that before, actually. And it was a situation where a client wanted to refund money. I told them I didn't think they needed to. And they said they really would feel more comfortable doing it. We refunded the money, and then the government came back and asserted an even broader overpayment. But in our overpayment letter, we said that if the government tried to assert an overpayment, we reserved the right to seek back the money we were voluntarily disclosing. And so the client actually refunded about $300,000. The government then came back and sought an additional $800,000, and we appealed. And when we appealed, we won back the full $1.1 million, including the amount that they had voluntarily refunded. I have to say, that is my proudest moment, I think, as a lawyer, was getting back money for a client that they had voluntarily refunded. And what CMS seems to be suggesting here is that if you are refunding money off of a sample, it will be more difficult to do that because you can't avail yourself of the reopening provision. But if the government came back and asserted an overpayment, that of course would be a trigger that would allow you to appeal on the claims that they assess the overpayment on. I'm not going to spend very long on this. I just want to mention that there is a case out there where an organization in New York got in trouble for not promptly refunding. That case is still in process. The facts in it are pretty bad. There's a long time frame where the hospital knew that it had problems and it didn't do much. And I think the key lesson here is you can't let the grass grow under your feet. If more than 6 months are going by between the time you've identified a problem and you're ready to cut the check, there's a risk that the government is going to think you're dragging your feet. So remember that an overpayment is money that you're not entitled to under the statute. So there are a bunch of things that are arguably not overpayments, and you don't need to voluntarily disclose money. I'm going to cover this quite quickly. We've got other webinars that go into this in more detail, and if you're intrigued, I can send you the links to some of those. But 3 biggies: poor documentation, violations of the conditions of participation, and reassignment. I'm going to talk in the future slides about the first two briefly. Reassignment is a situation where you build a service under Dr. A, or Dr. Smith, let's say. Dr. Jones really did the work. Medicare is very clear that if you bill under the wrong person, it isn't an overpayment. The manuals make that explicit. So you do not need to refund money because you billed under the wrong person, as long as the people involved were all permitted. You know, it's a different story if the person wasn't licensed or something and they weren't allowed to provide the service. That can make things more complicated. But if the service was otherwise reimbursable and simply billed under the wrong person, it's not an overpayment. So when you have to do voluntary disclosures, how do you go through this process? Because remember, this topic is not limited to 60 days. This is kind of generally on voluntary disclosures. Who should do an internal investigation? I am a fan of choosing your person based on who's going to be best received, and that may vary from situation to situation. You want to know who are people going to be honest with? Who's going to ask the next question? And what I mean by that is who's going to be properly cynical. I do think for most investigations, you want to have two people present in an interview because you might need someone to serve as a witness. Obviously, you need to think about the cost and privilege and things like that. Can an internal compliance officer do the investigation? Absolutely. That is in often the right way to do things. Can an outside attorney do it? Yes. Does it need to be the outside attorney? No. Can there be advantages? At times, yes. At times, it's best to have that inside person. I think you do it case by case. Now, there are different strategies you can use, and reasonable people will differ on this. I've seen people who use the bright lights technique. I am a fan of the Columbo interviewing technique. I want to make people comfortable. I want to let them talk. And I want to use the interview as a mechanism to educate them about what's going on. On the let them talk, I mean, I'm prattling on and on here. You can get a sense I can talk a lot. But one of the biggest mistakes I see in interviews is that the interviewer answers the question on behalf of the witness. I once did an interview with a lawyer from another firm, and we were trying to figure out how the client's compensation formula worked, and that other lawyer had helped draft it. And every time I would ask how a calculation was done, the lawyer answered the question, which completely undid the value of the interview, because what we were trying to figure out was not what the policy said. We all knew what the policy said. We wanted to know what actually happened. And so one of the really important things in an interview is not talking that much, but use the opportunity to help witnesses who may think the organization has done something improper to understand nuance if that nuance is present. Now, many of you can gather I'm not entirely conventional. One of my philosophies of life is be a salmon, not a sheep, as evidenced by, well, what do you know? I'm a follower too. Or I guess not evidenced by, but illustrated by. Be a salmon and not a sheep. You can do weird things. I have learned that phone interviews can be a really effective tool. You know, you might think I'm not going to hire a lawyer from out of town because we'd have to fly him here. I have done investigations over the phone, and if you have lots of documents, it doesn't work. But there are times I've learned that just like in the internet, sometimes people are blunter when they're not face-to-face with a person, and so they'll say stuff that might be jerky on the internet, but maybe is their more honest opinion. Similarly, sometimes in phone interviews, you can get people to say stuff that they really think that they wouldn't say face-to-face. Just an interesting aside, just because everyone does something some way doesn't mean you need to. When you're in the midst of a voluntary disclosure, you have to consider what's privileged. And remember, you know, you've got the attorney-client privilege that applies to things, communications directly with counsel, whether that's inside or outside counsel. Most of what happens in internal investigations, however, is going to rely on the work product privilege. And people often forget that that's not quite as broad as attorney-client. Work product does protect work done by a non-attorney. A compliance officer can do an investigation, and that's privileged. But the work has to be done in anticipation of litigation. And there are going to be situations where you may be doing a voluntary disclosure where it's harder to argue. But actually, if you're actually doing a disclosure, I think you'll often have a decent argument that it's done in anticipation of litigation. You know, if you're doing routine coding reviews, I think it's perilous to believe that that's done in anticipation of litigation. And then obviously, you know, you can blow the privilege by including people who don't need to know what's going on. There isn't a requirement that you label a document as privileged in order for it to be such. It's helpful for when people review it, but it isn't a requirement. Now, I'm going to do this very quickly because we could spend an hour on the next few slides. Instead, I will encourage people who have never heard me talk about this to watch a whole webinar on it. But if you've ever talked about audit results and talked about overcoding and undercoding, listen up. I hate those words, all three of them. I don't like calling things audit. I don't like overcoded and undercoded. The reason I don't is if it isn't written, it wasn't done, isn't the law. So you can click on this link here and watch the whole thing on it. You know, the gist of it is that under the law, you have to furnish information to support that a claim was billed. That doesn't have to be in the medical record. There's no reference to medical record here whatsoever. You just have to have information that supports a claim that's billed. So on a slide like this, I want to strike a bunch of words. I want to call things reviews, not audits. And I don't want to talk about something being undercoded. I want to talk about how the documentation exceeds the code, or the documentation doesn't support the code, or how it does. There are a handful of situations where Medicare explicitly requires documentation. Anesthesia, teaching physicians, and the like have explicit documentation requirements. But standard E&M services do not have an explicit documentation requirement. There are guidelines, but those guidelines are just that, guidelines. Okay, so you can listen to the that whole webinar. Another provision that's out there that you don't want to forget, I didn't know about this one until pretty recently, but there's actually a statute that says, other than national coverage decisions, nothing can, well, only regulations can narrow Medicare benefits. And this can be really useful because it means nothing in the manuals or in an LCD can get rid of something that Medicare would otherwise statutorily cover. And I should have noted on that last slide, re-emphasize, we're only talking about Medicare here. Medicaid in many states has an explicit documentation requirement. Some private payers, in fact, many private payers now stick in their contracts explicit documentation requirements. So the answer that I'm giving you for Medicare doesn't necessarily apply broadly across the board. Now, here are some hard questions about internal reviews. And I don't know why the Q's on this format look so much like they're the female gender symbol. But in any event, so big question. You do an internal review, you find a mistake. Do you just refund on the claim that you've looked at, or do you project to a larger universe? Here are some of the data we know. Back in 2001, when Janet Rehnquist was the head of the Office of Inspector General, she wrote an open letter that said that if you're subject to a corporate integrity agreement and you, through that, do an audit, and you find an error rate that is under 5%, you just refund on the claims you've looked at and don't project to a larger universe. So one thing I would say is I feel very comfortable saying with an error rate of under 5%, it's clear in my mind you don't have to project. Now, what about an error rate of over 5%? I think the answer isn't clear. I feel pretty good getting up to about 10% and saying you might just be refunding on the claims you've reviewed. If you forced me to point to an authority for that, it's going to be somewhat challenging. It is worth noting contractors have to have a high error rate to project, but that high error rate isn't defined, and you aren't allowed to challenge the contractor's decision to do a statistical sample by arguing that the rate isn't really high. So there's just a serious lack of guidance here. So if you found 10 claims and 3 of them have identical errors, does that trigger the duty? I'm going to be pretty nervous about that. If you find 3 errors and each one is different, that feels totally, I feel there, it's a lot easier to argue that you haven't created a duty to project. If you've identified a problem, how large a sample do you select? That's a really hard question, and there's once again no easy answer. You can hire a statistician, that's not cheap. And I'm going to tie this bullet with the next one, which is, do you use the same approach Medicare would use? So remember, Medicare uses the lower bound of the 95% confidence interval. I'm tossing out a bunch of questions and not really fully answering them. Do you do one sample that's for Medicare and Medicaid and all of your private payers? Do you have to do a separate one for each private payer? That's really, how would you do this? I am aware of no guidance on this whatsoever. I think you try to get pretty practical on it, and I am a fan, therefore, if you're doing a voluntary disclosure, of keeping it simple and doing one sample, all right? And I would probably use the Medicare approach, even with private payers. What could screw that up? Well, first of all, if your contract doesn't allow you to do it. Now, sometimes private payers have different limits. A lot of contracts now have a 1-year look-back period. So if you've got a 1-year look-back period in your private payer, you're not going to want to use the same sample you're using with Medicare because you're going back further. But one of the other challenges is a mathematical one, which is your payment amounts are going to be different, and that can mess up all of your calculations. So this is operationally really, really hard. I think a lot of organizations solve it by not doing refunds for private payers. And it's interesting because as aggressive as I am on willing to fight on stuff, I struggle more with the idea of saying we're not going to refund a private payer if we've got a problem. That makes me a bit nervous. If you do have a Medicare self-disclosure, you have to choose where to send it. You can do it either directly to the contractor, you can go through the self-disclosure protocol, and there are actually more than one of those. CMS has a self-disclosure protocol for Stark. The OIG has one for potential fraud. I am a strong proponent of refunding the money to the contractor. When you refund money through the self-disclosure protocol, you can assume you're going to pay a penalty, at least 1.25 times single damages. And basically, you're acknowledging that there was some form of intent. Now, you will get a release if you go through the OIG self-disclosure protocol, so that's worth something. But you're paying for that release in the form of paying more than just your refund. And I'm a fan of paying the refund. If someone wants to come after you, you might still have to negotiate something out. But I don't like the idea of knowing I'm going to pay an additional 25%. There could be some situations where I'm going to do that. But to me, if I think we've made a straightforward mistake, I'm going to refund the money to the contractor and see what happened. You know, you're going to pay a multiplier if you go through one of the self-disclosure protocols. So if you're comfortable paying that multiplier, great. But if you don't want to pay it, refund to the contractor. That doesn't get you an automatic free pass promising that there could be no False Claims Act case. But I think it's pretty hard for someone to bring a False Claims Act case against you when you've refunded the money. It looks kind of stupid. All right. We're going to bring this home with what you do and don't say in the refund letter, and then a variety of questions that I've asked myself and that you guys have asked. So do you ever send a placeholder letter? And my answer on this one has changed. You learn from your mistakes. I used to be inclined not to send a letter. And when I say a placeholder letter, I mean if you've discovered a problem and you know it's going to take you 6 months to figure out what's going on, do you ever write and say, hey, we've identified this problem, we're working on it? And I'm still not always going to do it because I just had this with a client. They told the government, hey, we think we've got this problem, and then 2 months later we decided it wasn't a problem. And now you have to call the government back and explain it to them, and they disagreed with our assessment. And if we had never told them what was up, we would have been fine, but now we're in a situation where we're going to have to duke it out with them. But it really hurts when you are working on a self-disclosure and then a government investigator shows up at your door and you have to explain that, yes, you really were going to send the money back and they think you were holding on to it. So I now, in certain circumstances, if I think it's going to be a long time and the problem is big enough, I might send in a letter saying we've discovered this problem, we're working on quantifying it. When you send in any letter, I do not believe that that letter should come from a lawyer. I think the letter comes from a business person, which isn't to say that a lawyer shouldn't review it. I think your in-house or outside lawyer should review these letters. They're a big deal. Wording really matters, as we'll talk about in a minute. But the signatory should be a business person. As I said, write to the contractor. You have to explain why there is an overpayment. You have to make sure your detail is right. When you've got a situation where you've got a small issue and the cost of the investigation exceeds the overpayment, I'm very direct about that. Just tell them that's what's up. Explain it. Say, hey, we're rounding up. We want to make sure we are treated fairly, and that's how we're doing this. Now, there are a bunch of things you don't want to say in a letter. So everything that's in red on this slide, I don't like. I don't like the recently because one man's recent is another woman's slow. Just get I take those references out. Obviously, you don't want to say you were committing billing fraud. That's the kind of admission you don't want to make. If you merely weren't documenting services properly, I don't think there's necessarily an overpayment. I don't think you inadvertently billed. I think you billed intentionally. So I'd get rid of that word. We did a statistically valid sample. Well, only if you really did. That's hard to do. And I think you often think you've corrected a problem, but you didn't. So I avoid all of that stuff. But here are some tips. This may be one of the more important parts of our webinar. So if you've daydreamed, perk your ears up here. I start every refund letter with the same words as part of our ongoing compliance process. Whether you have a compliance plan or not, and I hope by now you do, the government basically thinks if you don't, you are inherently breaking the False Claims Act. But whether you have a formal process or not, when you're refunding money to the government, it's part of a compliance process, period. I like to say, I use the phrase more appropriate. I don't want to have admissions in this letter. And so I don't want to say that we did something wrong. I'm saying that there's a spectrum, and this way is better than another way. Similarly, I might refer to something as a possible issue, or the level we're confident defending. It highlights that there are arguments to be made that something else is possible, and that this letter isn't an admission. The main thing I want to avoid is a situation where you send money back and the government uses your good deed against you. You know, that fourth bullet is the story I talked about before, and I won't repeat it here, but I will often include the ability to recoup the voluntarily refunded money if the government treats you unfairly. So that's a lot about this letter, is making sure it isn't shoved down your throat. That's the same reason I don't refer to something as an overpayment. I feel like you've then admitted that you weren't entitled to the money. Call it a refund. You're choosing to do this. Whether it's required or not is open for debate. You don't have to acknowledge that it's required here. It's a voluntary act you're doing. And so I never, ever use the word overpayment to describe what's going on. I talk about money we're refunding. If you say, our attorney told us, that statement, when made to a government person, may arguably waive the attorney-client privilege. So I avoid all characterizations of or repeating advice from counsel. And then if I think we've fixed the problem, I might say, here are the steps we're taking to improve the problem. You still have some of the same issues, but it's a little better. All right, what do you do with copayments when you're doing a voluntary refund? The law isn't entirely clear, but generally speaking, I think size matters here. If you would bill the patient if they owed you the money, I would generally refund it to them. Some states require you to refund the money or have an escheat law that says the money would go to the state. If you've discovered a problem, you have a choice to make. Are you rebilling the claims or refunding? Rebilling is a lot of work, and often I am a fan of the refund. Sometimes I've seen payers insist on a rebill. A few things to keep in mind: I've seen payers insist on a rebill and then apply a claims filing deadline to say you can't go back more than a year, and so all that other money is just forfeited. And if one of them tells you that, I would tell them where they can go, and it wouldn't be a nice place. It's very warm there. You know, I do understand why insurers need good data and why they may want you to refile as opposed to refund, although that also does create a processing issue for them. But if you owe, you know, if you build a level 4 and it should have been a level 3, you shouldn't get paid 0 for that. You should be, the amount that's going back is the difference between a 4 and a 3. And so whether you're rebilling or refunding, that's the way to do it. If you can possibly refund, it's easier for you and probably easier for them. One of the challenging things about refunds, let's say you have a short stay audit, you're a hospital, and you refund, you look at 100 claims, you find an error rate of 10%, and then you refund on 1,000 claims. Now, you don't know the specific claims, right? We did a sample. Fast forward 6 months, and Iraq comes in and does a short stay audit on you. Let's say that they actually, let's make it easy, they find the same 10% error rate. You've refunded, right? But you can't point to which claims you've refunded on. This is hard and not I haven't seen this in action much yet. I've had the problem once, really, but it's going to come up more and more. You need to keep a good record of what your refund is, and then you have to try to explain it. If they're looking at particular claims, you've got this pickle of, you have a sample. You can't prove you refunded on this claim. Was that particular one part of the sample or not? How do you get there? This is hard. I don't have magical answers. I just tee up the question. Private payers, remember your contracts and manuals control. I hope you're reading your contracts. No one does anymore, but they matter. The refund requirement is only applying to the government statutorily, but keeping money from a private payer is arguably health fraud and could be a federal crime. So I don't understand why people are so willing to ignore overpayments that they've received or money that they may arguably owe back to a private payer. State statute of limitations might apply in addition to any contractual limit. And if you're thinking about a Medicare Advantage plan, there's the question, is Medicare Advantage a private payer or is it Medicare? And for purposes here, I would say it is a private payer and the private payer rules apply. Now, we got a bunch of questions. I'm going to try going through those. You can keep sending these in. And, excuse me, first, I'm going to have a drink of water. So first, a person has identified an overpayment. This is a great question. What's a person? And I should have brought my copy of the regulation down. This person is an idiot and didn't. I believe person here, I am confident person is defined to include organizations. There's a statute that says whoever has knowledge of an event affecting their initial or continued right to any benefit or payment under a federal health care program who conceals or fails to disclose the event with an intent to fraudulently secure a benefit is guilty of a felony. And there, person didn't include the corporation. But here, I believe it does, and I am really mortified that I don't have the answer to that in front of me. I totally should. I'm stumped. If the person was here, they'd have won a prize. Can Medicare contractors make you rebill versus refund? Well, make is an interesting word. I went through this, oh God, I had a situation where our client didn't have, they had hundreds of thousands, well, I guess it was at least thousands, maybe 100,000 claims they wanted to do. And the contractor was really, really, really trying to make them rebill. And we were really, really, really obstinate, and we eventually got to the point of a refund. So can they make you? So far, I have not seen the answer to that be yes. We've always been able to refund in there. Would they have the legal basis? I guess it's possible, but I would hold as firm as you possibly can. It makes no sense to me to rush into a projected review based on a 5% error rate if you found in a routine 12-sample audit. Would you agree? Some people would doing projected reviews left and right unless you exclude all E&M level findings. I would completely agree. You know, if you've got one mistake, well, okay, back up a step. In an E&M review, I don't think you've got an error. If you look at 10 claims and you find 3 of the claims lack documentation, for purposes of overpayment, you do not have a 30% error rate because we have not yet determined that there's any overpayment. We've determined that there's insufficient documentation. And that's where the whole, if it isn't written, it wasn't done, isn't the law becomes important. We've only determined we didn't meet the E&M guidelines. And so I don't think there's any overpayment at all until you figure out whether the code was billed properly. If the doctor did a 99214 and only documented a 213, but billed the 4, there's no overpayment. There's poor documentation. And it's an error in the sense of not ideal documentation, but it isn't an economic overpayment error, all right? So that's a really important clarification. Now, let's say you looked at 12 Incident 2 services and found one where the Incident 2 guidelines were not met. I still think if it were one, I think I'd say it's one and I'd move on. It's my personal opinion. You know, where do you draw that line if it's 2? I might also exercise a little bit of thought if I discovered in the course of that, oh, someone didn't know the rules and we were completely ignoring them. That might affect my thinking. But if I found 1 out of 10 on something, I would be less likely to do it. But that's personal opinion. This is Glazer opinion. This is not, I'm pointing to clear rule. Can RACs take back money based solely on documentation questions? What's the best course of action when this happens? Well, this is, can you? This is yes, they can try to. Should they win? No. What do? You fight. And also remember, it depends. If the documentation issue is if it's an anesthesia claim and you haven't documented the 7 elements in accord with the regulation, or if it's a teaching physician thing and you haven't documented in accordance with the regulations, there I wouldn't necessarily appeal because I think we'll lose. But if it's an E&M, I absolutely would fight tooth and nail if I think I can support it one way or another. We got just a couple more questions and then we'll wrap this up. I will say, since I know we're at the end of the hour and some people are going to have to go, remember that our July webinar, which will be on July 13th, Bastille Day Eve, on Bastille Day Eve, we were going to talk, Steve Beck and I will talk about value-based purchasing type topics, a little bit about MIPS, a very short discussion of CJR and other things. Don't forget to fill out the survey at SurveyMonkey. The link will be sent out shortly, and hit us with that. And I feel like I'm missing one other thing, but I'll just dive on with the questions because. All right. So you've got an LPN, a licensed practical nurse, working in a SNF without a license for 2 months. Is that an overpayment? So this is an interesting question. And you could spend a long time on this. These are the stuff, this is where us lawyers often earn our keep. Although I'm going to start with a little bit with it. It depends. So one of the questions is that person providing billable services or not? Because the things that that person did, if they're not licensed, are generally, I'm going to be hesitant to count them towards the bill. Now, if they were excluded, which is different, this is about unlicensed. If they were excluded, Medicare takes the position that you basically owe money back that's in an amount based on the amount of money that you put on the cost report for that person's salary. And they'd say, take their salary, multiply it by the percentage of people that are Medicare and Medicaid, and that's the amount that's due back. Unlicensed is a different critter. And the question I usually ask myself there is, let's say that we could go back through time. I guess we would, for those of you who were on at the beginning, we would talk about Star Trek, and well, they don't really do time travel there, but some other sci-fi world. Pretend that this LPN had not existed. If the reimbursement you would have received if that LPN had never been born and never provided any care and the care that was provided to the patient had never happened is the same, I'm generally going to argue that you don't have a refund that's due. And so I'm going to treat that slightly differently than an exclusion. Now, if there is work that person did that's billable, I think you've got an overpayment and a refund. So you identify an error, but you fail to refund in 60 days. Let's say you get the refund in on day 68. What are the consequences? Well, first of all, a couple of things. Remember when the clock started to run, right? The clock didn't start to run until you'd quantified the error. So don't think that if you got the call and it's now been 68 days that you're in trouble, because you're not. But if you quantify it and then you screw it up, well, what you've now arguably done is created a false claim, and someone could argue that the amount of that overpayment has been improperly billed. It's a false claim subject to treble damages of that amount, and then $5,500 to $11,000, really, and for each of the claims that you didn't refund. So it's not just that's out there. What would I do if I'm in the situation? I get the money back as fast as I can, and then you hope no one squeaks about it. All right, I think this will be our, well, we have two questions. This is a great one. What if the RAC identified an overpayment, but we appeal? They actually handle that one very clearly in the preamble. If you are going through the appeal process, it's not an overpayment yet. You can wait until that is resolved if you disagree with their findings. And I think we've got at least one or two more here. What advice do you give for auditing and monitoring programs under the rule? It seems like we're penalized for being proactive and following the federal sentencing guidelines. It does feel a little crummy. I think it is helpful to do some reviewing because I think you want to know what's going on. I still am a big fan of education, but I think especially in light of this new, I was a fan of doing some like E&M reviews anyway, but with the CMS position here, I think it's kind of crazy not to do some reviewing. I would do it. I just wouldn't go, like if you're doing on E&Ms, you don't have to refund every time you find a documentation deficiency. That's the mistake. And truth is, if you find that you are systemically billing things you're not entitled to, then, you know, I don't feel like you're being treated unfairly. Where I think you're being treated unfairly is if you're giving money back for services that you provided. And that's where I want, honestly, us to earn our keep. That as lawyers, you know, we at Fredrikson and Byron, really, if Fredrikson and Byron can do one thing for people, it's help them keep the money that they're legally entitled to. That's what we want to do. And so if you've provided the service, we want to help you not have to refund, all right? That's our job. It's come up with every argument in the world that if you really did the work, don't cut a check. And compare that to a situation where you billed for something you didn't do. And there, you know, honestly, I'm not going to feel as good about myself if that's not my goal in life, is to help people get money they're not entitled to. It's to keep the money that they are entitled to. So hopefully that's a fair answer. And so if your review finds something and you really did the work, I think you're not going to have to do a refund. Okay, I think we're going to call it a day there. Thanks all for listening. I hope this was at least a little bit useful. Remember also, if you've got colleagues who you think wouldn't mind suffering through this, in about 24 or 48 hours, a link will be up and you can send them this. It's free, and they can watch it at a later time. And it'll be out there for a while yet. And remember, for those of you who are at AOE, please come up and say hi. Thank you so much. Thanks to Marguerite Amin, our newest health lawyer, who helped me sort through all of these questions. And have a lovely day.